This section embodies the rule that the testimony of res gestae is allowable when it goes to the root of the matter concerning the commission of the crime. The conduct of a person involved in crime becomes relevant if his conduct is related to the incident that happened. Where a crime has been committed, the court has to take into account both the previous and subsequent conduct of the accused pertaining to the commission of the crime. In certain cases, the previous conduct of the accused throws light on whether the accused is innocent or guilty, whereas in some cases it is the subsequent conduct that becomes very important in determining the innocence or guilt of the accused. In the present case, deceased was found in the morning near the room of the accused. Deceased had gone to sleep at night in front of the room of the informant, who is his son, and the informant and his family members were sleeping on the terrace of the room. When the informant and his family members came down in the morning, they found that the accused was cleaning the blood stains with the broom, and on seeing the informant and family members, the accused went into his room and locked his room. The said facts have been duly testified by the witnesses produced by the prosecution. The said facts are relevant under Section 8 of the Evidence Act and indicates towards the fact that the accused is guilty of the offence. A witness is normally to be considered independent unless he or she springs from sources which are likely to be tainted, and that usually means unless the witness has cause such as enmity against the accused to wish to implicate him falsely. Ordinarily, a close relative would be the last to screen the real culprit and falsely implicate an innocent person. It is often the case that the offence is witnessed by a close relative of the victim, whose presence on the scene of the offence would be natural. The evidence of such a witness cannot automatically be discarded by labeling the witness as interested. It is worthy to note that there is a distinction between a witness who is related and an interested witness. A relative is a natural witness. The apex court has opined that a close relative who is a natural witness cannot be regarded as an interested witness, for the term interested postulates that the witness must have some interest in having the accused somehow or the other convicted for some animus or for some other reason. Merely because the witnesses are family members, their evidence cannot per se be discarded. When there is allegation of interestedness, the same has to be established. Mere statement has been relatives of the deceased, they are likely to falsely implicate the accused, cannot be a ground to discard the evidence which is otherwise cogent and credible. Relationship is not a factor to affect credibility of a witness. It is more often than not that a relation would not conceal actual culprit and make allegations against an innocent person. Foundation has to be laid if plea of false implication is made. There is no bar in law on examining family members as witness. Evidence of A related witness can be relied upon provided it is trustworthy. Stop.